My dispatcher owes me $8,000, taking them to small claims court. Welcome back to Reddit Court Files, where we pull real stories from Reddit and put them on trial. Today's case comes from r/smallclaims. Quick note, nothing in this video is legal advice. We're storytellers, not lawyers. Now, let's get into it. Our story opens in the bustling world of auto transport, where one independent hauler, a savvy entrepreneur with their own truck, trailer, insurance, and operating authority, found themselves navigating the challenging landscape of logistics. For months, they'd been working with another transporter, an arrangement built entirely on a verbal agreement and a consistent course of dealing. Initially, our narrator balanced their own customers with the loads provided by this partner. But as the work from the partner became consistent and reliable, they made a strategic, albeit risky move. They dropped their own customers, putting all their eggs into this one basket, relying primarily on the work their partner was dispatching. From day one, our hauler did something crucial. They kept a meticulously detailed ledger. Every single load completed, the exact agreed amount for each, every payment received, and a precise running balance owed was recorded. Early in the relationship, payments were prompt, often landing within 24 hours of delivery. This consistency, this promptness, built trust, reinforcing the narrator's decision to keep accepting work from this company. But slowly, almost imperceptibly at first, the cracks began to show. Payments started arriving later and later. The outstanding balance would occasionally creep up to around $2,000, but then, true to form, a payment would come through, bringing it back down. This history of eventually paying, despite the delays, kept our hauler committed, kept them on the road. Then, during the latter months of their business relationship, things took a dramatic turn for the worse. Payments became increasingly delayed, some loads went unpaid for extended periods, and communication grew inconsistent. The excuses for non-payment became frequent, a constant stream of reasons why the money wasn't there yet. Despite the mounting frustration, our hauler felt trapped. They had already shifted away from their own customer base, fully reliant on the loads being dispatched by this company. The pattern solidified, multiple loads completed in a week, only partial payment, if any, for prior work. The balance just kept growing, steadily climbing higher and higher until it reached a staggering $8,000. Eventually, the loads themselves became less frequent, communication dwindled to nothing, and finally, the other transporter simply stopped providing work altogether. The $8,000 balance remained unpaid, a stark testament to months of labor and trust betrayed. But our hauler wasn't one to simply roll over. They had built their business on precision, and that precision extended to their records. Throughout the entire relationship, they had been diligently sending updated balance statements to the other transporter, typically every single Friday. These statements clearly laid out every completed load, every payment received, and the current running balance owed. Crucially, the other transporter never once disputed the amounts shown in those weekly updates, not a single challenge. Beyond the paper trail, our narrator was relentless in their pursuit of what was owed. They regularly contacted the company regarding payment. Sometimes there would be a response, more explanations, more promises to pay. Other times, total silence, the messages simply ignored. There were multiple occasions where payment schedules were explicitly discussed. The other transporter agreed to repayment plans more than once, shaking on it, confirming the terms. But when the agreed start date for payment arrived, the money either wasn't made, was postponed with yet another explanation, or the communication vanished altogether. Our narrator knew they had a fight on their hands, and they were ready. They meticulously compiled all their evidence, that detailed ledger, maintained faithfully from day one, showing every load, amount owed, payments received, and the running balance. Records proving the history of payments that were made, establishing the past course of dealing. A treasure trove of text messages and communications, directly discussing payment. The messages where those broken payment plans were discussed and agreed upon. Every single one of those weekly balance updates, sent consistently throughout the relationship, never disputed. And of course, ironclad documentation of every single load they completed. With this formidable arsenal of evidence in hand, our narrator prepared their first formal salvo. A demand letter, giving the other transporter a strict 10-day deadline, either to pay the balance in full or establish a viable payment arrangement before legal action would commence. The question now was, based on these facts, was this a viable claim in a Texas justice court, specifically small claims? How much weight would all this incredible documentation truly carry? Armed with such a meticulously documented case, the path forward for our hauler in Texas justice court looks not just viable, but incredibly strong. The fact that the other transporter never disputed the weekly balance updates is monumentally significant. It's an admission, an acknowledgement of the debt without having to say a single word. A detailed ledger, a full payment history, proof of completed loads, and direct communications regarding repayment plans and missed payments. These don't just carry weight, they form the very foundation of a virtually unassailable small claims case. There's little else our hauler could have done to strengthen their position. They essentially built the perfect case as they went along. When faced with this kind of undeniable evidence, especially in small claims, where the focus is often on clear facts and straightforward proof, the defaulting transporter would have very few legs to stand on. The repeated agreements to payment plans, followed by their subsequent breach, further underscore the legitimacy of the debt and the other party's consistent failure to uphold their end of the bargain. Our hauler isn't just claiming $8,000 is owed. They can prove it, load by load, payment by payment, and message by message. This isn't just a win in court, it's a win in preparation, a testament to the power of diligent record-keeping. Turns out, in the world of verbal agreements and broken promises, detailed documentation truly is the ultimate legal shield and sword. That's the verdict on today's case. Drop your thoughts in the comments. Was justice served? Make sure to subscribe so you never miss a filing.